So we have the honor to have Cindy with us, a good friend, and you already have her bio. My former boss, I love her because she's really, she has the knowledge and the character, and also she has been a fundamental a piece of different programs in different universities, in different organizations, and also in terms of regulation in the nonprofit sector. So she has all. And for me, it's an honor to have Cindy as a guest speaker for our class today. Cindy, thank you for accepting our invitation. Thank you for being here and for being so active in terms of working in the nonprofit and in the sector that actually need more people like you. So, Cindy, my first question: how you see nonprofit are corporations? So you have the for-profit there, and you have the nonprofit. The nonprofit, how the nonprofit fits in this corporate world and in this structure of a business that we have.
It's a great question. And Carlos, I'm really, really grateful that you asked. It's always an honor to be in your classes. So you students have really, you have a home run here when you've got Carlos as your faculty member. So great job. So I'd like to think, like, step back for just a moment. I know that you have a lot of different topics to cover here in your course, and I know you're having some other experts also. One way to think about framing what we're talking about when we talk about legal and somewhat extra legal issues that come around is this pyramid idea, which is, for non-lawyers in particular, I think this is important because, and by the way, you can be a senior leader in the sector and still have to be figuring this part out. But the very baseline is, what is legal compliance in the sector? And Carlos's question actually goes to that. So I'm going to talk about that. But separate out in your mind, if you will, then the next layer, which is best practices. And a lot of governance actually comes down to best practices. There are not as many legal requirements around governance. There are guidelines. There are things that we will talk about in a moment, particularly at the state level, that state regulatory issues that help with governance, because governance is an ancient concept. It comes from common law. It comes from other fields even. It comes also from the corporate side, which we'll talk about in a moment. So best practices is the next layer above kind of legal compliance, which is the baseline. And you need to be aware of. So it's good you're taking this course. And then the very top level I think about is ethics, which a lot of people never get to, but is something that I'm actually currently writing on with some of Carlos's and my own colleagues from other walks and worlds. So thinking about, as a non-lawyer, what you have to know about law in this place, one way to think about it, and we do this in the law, is to think about issue spotting. And that is, in your shoes, what is it that I need to go get a lawyer for? It's not because you need to know all of this stuff. It's because you need a framing around it so that you can sort through it and analyze it and say, which parts can we handle internally, and which parts either do we need the knowledge of a lawyer that actually knows in this space, or frankly, we need to make sure we can be able to say that we consulted a lawyer, because that can be good governance. It's an indicator of good governance, which really matters, especially at the state level if you're talking about legal regulatory challenges, but also just because it's, of course, how you keep within your mission and do your best work. So at very base, nonprofits are, in fact, nonprofit corporations. The name, as you probably read in various readings, we always seem to define this sector by what it's not. We say it is not for profit. We say that they are tax exempt. We don't necessarily have an affirmative way of saying what we are talking about when we talk about charities. When you enter into the legal space, we're thinking about nonprofits, we're thinking about 501c3s. And that's a code within the IRS code, right? That says, hey, you're special. And when you apply, and many of you are, if this were a live class, I would ask for a show of hands, how many of you have actually founded a nonprofit? And probably about a third or more of you would be able to raise your hands. I jokingly say, you know, every high schooler that goes on to a good school these days can put on their resume that they already started a nonprofit by the time they get to college. It's a thing. Probably too much of a thing for a lot of people. It frankly should have more gravitas than it does at times. We make it super easy to have nonprofit status in this country. it goes back somewhat to another big legal concept, which is the First Amendment. We really do believe in nonprofits in this country being part of speech and freedom of association and the ability to voluntarily associate in the way you want. So when we think about the difference between a business, a for-profit corporation, and a not-for-profit, as I'm sure Dr. Ponce has told you, and you've read many times over now, it is baseline that the biggest difference is that you cannot actually distribute any of the profits, any of the revenue, any of the resources to shareholders in a not-for-profit. And in fact, in some states, they're actually called non-stock corporations. They are corporations that do not issue stock. The notion of a private business, of a corporation, whether it's publicly held or privately held, is that it actually has a duty to maximize profit. And that profit is then redistributed to the people that either own it or to the people that have invested in it, et cetera, whether it's public, privately owned, right? So the big difference when you get tax exemption for a not-for-profit is that you can still make money. It seems to be a fallacy that urban myth among some, that somehow not-for-profits can't make money or bring in revenue. We have that mechanism. We also have UBIT, which actually regulates that, unrelated business income tax, that can also be taxable. But the bigger issue is that whatever is brought in, those resources have to be redistributed only to the mission. So it has to go through programming. It has to go back into the nonprofit, plow it back into the nonprofit so that the mission continues. If a resource comes in as a donation, if it is done through its not-for-profit status, if it is represented in any way that those resources, whether in kind or financial, et cetera, or human, if they are going to be used for the mission of an organization that says and holds itself out to be a not-for-profit, what I say is those resources have to stay in the donative stream. And so they can't be redistributed. You can't just say, hey, board, we will give you all an extra $10,000 this year for serving on the board. In fact, it's actually an issue and something you could ask your governance expert that comes. It's an open issue whether any nonprofit boards should ever have paid board members. I mean, even a modicum, even an honorarium, because the big issue is whether or not that actually is something that keeps all those resources in the donative stream, right? So this, from that basic comprehensive idea, come most of our governance issues and guidelines, and also most of our IRS guidelines, that you cannot do something within a nonprofit environment and take it and benefit yourself. We call that private inurement. You cannot do things that have a conflict, that present a conflict, whether you're a board member, an executive director, or even a volunteer. That's not a waivable conflict. Under the law, there are such things as waivable conflicts, but many conflicts are not waivable in our world, in the nonprofit sector world, because it's not really up to you whether or not something can be given to somebody or an extra deal can be cut there under fair market value, for example, for services or things like that. The whole idea is that once you have actually raised money or brought in resources based on the idea that you are representing, that you are doing this on behalf of beneficiaries somewhere, you have essentially just created a charitable trust. If Carlos says to me, or if I say to Carlos, please give me $5, and it gives me $5, you didn't create a trust. But if I say, please give me $5 because I'm going to go give it to the Save the Greyhounds, now there has been a trust created such that I don't get to keep those $5. They have to stay in the donative stream and go to where they were supposed to go. And that is very different than a corporate duty to maximize profits. It's not just optional. Now, this is why the SEC, this is why FINRA, this is why all sorts of different guidelines exist about how to do business, transparency, ethics, all of those things. You can't defraud people in order to maximize profits, right? But you are supposed to do that. And you are not just allowed, but supposed to. You can do all of those things except redistribute them to humans, to people that actually work in the nonprofit or outside in the for-profit world. So that's at a very high level understanding, but that is the, as we say, going back to the pyramid I described, the baseline of legal compliance. And if you sense at any time in your practice as a nonprofit leader or manager that you're questioning, wait a minute, where is this going? Where could somebody make the case that this is not staying in the donative stream for the mission? And that's broadly written, right? It can mean overhead, it can mean services, it can mean salaries, it can be real estate. It could be that you're having to pay for intellectual property. There are many things that you can still spend money on, but you can't go around giving it to humans who aren't supposed to, or just because they're attached to the nonprofit, or because they're randomly somebody you decide should be the beneficiary. It doesn't work that way. Now, I will make one more comment before I end, and Carlos can let me know how to proceed from here. I often remind people, you can give away your money any way you want to and never have the government involved. The government becomes involved when you want to give away your money and get a tax benefit for it. The government becomes involved when you ask for resources, as I gave you an example a moment ago, on behalf of somebody else, because you are now the trustee of that resource, and it must continue on to the beneficiary. So just to be clear, not all philanthropy engages in all of this. But once you have become a nonprofit, once you have become, even if you don't register, if you don't actually get nonprofit status, registering it or submitting a 1023 or 1023-EZ, doing all that, the act of taking money on behalf that you are holding out is on behalf of someone else right there creates the trust. You've just attached the jurisdiction of a state or DC. If you don't do those types of actions, you can give away money all day long. You can like let it fly from an airplane if you want. You can hand it out on the street. You can give it for all sorts of, apart from certain election regulations, you can give it to almost anybody you want. Because again, in this country, the Supreme Court, through the Citizens United and other decisions, has said giving money is part of speech. And that includes for the philanthropic sector, but you're attaching jurisdiction once you do these other things that notch it up a level. Is that helpful, Carlos? Wait, we can't hear you.
Very helpful. Yeah, I almost forgot how good are your classes. Yeah, I was enjoying your class. Just got lost. So how it works? So as simple as you can, the regulatory framework for the nonprofit sector. We have state, we have the federal government, all of them involved, because we have the public trust involved, as you mentioned. So nonprofit, 501c3 or 501c4 have more open in 501c6, but the 501c3, the charitable, in this environment, so state, federal, so as simple as you can. So how is the legal framework?
So the ancient framework that we have actually comes from common law, which is Great Britain. It's the UK law in terms of, and it's all over the world now. Well, certain parts of the world. The global regulatory landscape looks very different in certain parts of the world. Broadly written, and I don't know how many of your students may be international and do work internationally, but broadly written, the UK kind of had the longest, what we call common law, which means it grew out of, this is just how we do things. And property law is a really great example of common law. Like, it didn't take statutes to say that if the fence line is here and you know that you bought this land, you're not allowed to go over into the other land, right? Things like trespass law and things like that. Property law, very, very old. Fraud is part of very, very old law. These are common law concepts, right? So all of that was exported to places like the US, Canada, Australia, New Zealand, These are essentially either places that were colonies or had some attachment to the original. And this is about 600 and some years ago that we finally had the statute of uses and that we have statutes starting to be created in the UK environment. And that was really, again, a lot of it grew out of either property law or because there were religious entities involved and there were trusts involved there as well, and also charitable hospitals. Because hospitals and medical care back in the day, you know, you had a private doctor that came to your home many hundreds of years ago if you could afford it. And charity hospitals were what existed for the rest of the masses. And those were nonprofits. So from all of that, once it was exported, and I'll just note that in other countries, even within Europe, there is a split about how regulation goes. Certainly in other environments, there is even less regulation than, you know, anything across the world, but they may have some. And again, it could be a combination of something that's related to things like fraud versus statutes that are very, very specific to this part of the legal code. There is, just as a sidebar, one of the most comprehensive, probably the only comprehensive look at the global index is at Indiana University, where I am now, and it's called the Global Philanthropy Environmental Index. And one aspect of their methodology is to look and talk to legal experts in 92 countries. And part of my work is going to be hoping to help kind of expand on that with a regulatory lens and a legal lens, because the folks that do that survey and all of that are not lawyers at the top level, but they're experts in philanthropy globally. So once you start looking at the US, we had a long-standing series of both common law and state law statutes. It started mostly in the Northeast, and a couple of major Supreme Court cases that were like, hey, yes, this is what it means to be a trust. This is how a trust could be enforced. Here's how we're going to define a trust. All of that was starting in the US very, very early on. Higher education was one of the places that it started in the US. This was very much, you know, yes, people are going to donate to higher education, and therefore, you know, Dartmouth is the famous case early on that said, yes, there are elements of this that are nonprofit and people can't just take it over and do whatever they want with it once resources have been donated. It is only in the last 100 years or so that we have had a tax code that actually addressed these issues at the federal level. Now, most people think about that the federal level is where, you know, they think the IRS for everything tax exempt. And there is reason for that, although I'm going to push back a little bit on that. And I actually have an article that I think is useful in explaining this. It was an interview I did for Nonprofit Quarterly some years ago, where I explain kind of this landscape. I think it's useful for non-lawyers. And I'm happy to give Carlos a link to that, and you can find it. But the idea here is that the IRS only gets its authority to grant tax exempt status from Congress. Most people never think about that. Didn't seem all that important. You know, once they passed the statutes, it was kind of like, okay, we'll mess with them around the margins, but not a big deal. But it's come to pass that it's actually very important that people understand this, because some years ago, when there was some activity around, you know, people had different views about this, and there were congressional hearings around this, there's an idea whether or not the IRS was leaning harder on Republican entities during an election cycle that were Republican-based or conservative-based, nonprofits that were trying to they said they were not doing political activity, but also there were Democratic and more liberal leaning that were also trying to get in on the space. And so it turns out that the IRS was told by Congress, we're not giving you a budget for a lot of enforcement. We are asking you, telling you that you are not supposed to be doing certain types of activities vis-a-vis applicants. That's not an opinion, that's a fact, and it's in congressional hearings. And one of the outcomes, as I say, was that Congress has the budget power, the purse string power over the IRS on this. So it is important to know that the IRS's authority here is only delegated from Congress, who are elected members. That matters, right? When the IRS just got, the IRS has woefully been behind on having, for some years now, the amount of expertise they need in the exempt organization space, all sorts of things. I sat on the IRS Exempt Organizations Advisory Committee, which is no longer, there's no longer a bridge between the IRS and the sector that is an official platform or communication. And I say all this because it matters, because they do come up with all sorts of regulations that you have to abide by in order to continue your tax exempt status. So there are other players and other folks involved at the federal level. It's not just about the IRS. In fact, the U.S. Postal Service has a piece of it. The Department of Treasury has a piece of it. The Department of Homeland Security, terrorism, has a piece of it. So there are other players at the federal level, right? Okay. At the state level, which for a very long time, people, in my opinion, just kind of took for granted. I used to be the director of the National State Attorney General program at Columbia Law School. And one of the topics that we decided to do work on, it was just one at the time, along with environment and labor and a bunch of other things, was around charities. And it came at a time where a lot of foundations were very interested in this as well. A lot of people think of policy in this space as only at the federal level. That's not true either. The states actually, because of this common law notion that they have had expertise across the states. They have had cases, they have regulations for a very, very long time. But they're hard to get your head around because every single state is different, which is the nature of federalism. See the 10th Amendment. So federalism is allows states to say, well, we want to do it this way, or we only want to have statutes on fundraising. We have states in this country that have no registration requirements whatsoever. And then we have a slew of states that do. If you are interested in that, you can look at the legal compendium that colleagues and I put together over the years and are in the process of updating for a third time on the Urban Institute's website. If you're interested in more of this, there's a whole bunch of things there that we've done. And we go through all the different states in DC about all sorts of different regulations. And just from that, you see this breadth of ways to regulate, which is hard for people to get their head around. And it really wasn't until, other than one person, very well known out of Boston, Marion Fremont Smith, who passed away just last year, there really wasn't anybody studying this at the state level. And that's where I stepped in eventually. And that's what I've been studying for quite some time. The states focus on governance issues because they can. They focus on the trust, charitable trust. They focus on governance, good governance, because all of that comes out of common law, which is where there is no federal common law. The states are where we have common law, which came from the UK. Then they also have their own statutes. See the legal compendium at Urban Institute's website. Taken together, the states and the feds have what I call interlocking jurisdiction. They rarely overlap. The feds want to do governance, but it's not really in their jurisdiction, but there's a little bit of governance and regulation, regulation on governance in the 990. But for the most part, the states do their thing, the feds do their thing. In fact, there's this major statute that's problematic that prevents information flow from the IRS to the states on cases. It can go the other way, but it's a one-way valve. So they try to do what they can together, but there's not a lot of interaction there. And in the old days, the states were kind of also on their one-off. Sometime around in 1990 something, when I was in a state attorney general's office, I wrote an article with my AG around this new crazy thing, the internet, and how jurisdiction would be impacted by it. Because now you could cross lines without needing to. You could do it easily and overnight. And at the time, it was hard to track things. We figured out now you can't not be tracked on the internet now. But when it first started, it was a question of like, well, what happens with fraudsters when they want to set up this crazy internet site thing and they want to fundraise and then disappear in the night, right? So that piece of how states do their business over the years has changed tremendously. They talk to one another. They have all sorts of shared platforms. NASCO is their major association, National Association of State Charities Officials. And within the states, you will also see a paper on this on the Urban Institute website to explain this. Best place to start is the 2016 research study that the colleagues and I did. But there's a paper on bifurcation. In some states, there are different offices that deal with jurisdiction and charities. The Attorney General's office always has jurisdiction, but occasionally in other states, there's another office, like the Secretary of State will help you set up your articles of incorporation and may have some jurisdiction. In some states, it's another department. It could be embedded in the Department of Agriculture. What does that mean for you as a non-lawyer? It means that you have to really be clear about what states you operate in. Doesn't just matter where you're incorporated. That's a big one. A lot of people have headquarters in one place, but they're actually incorporated somewhere else. You need to be really aware and clear, and all of your executive staff and your board, where are you incorporated? Where are your headquarters? But also, where do you do business? Because in the legal sense and in the legal world, what we care about for jurisdiction purposes is who are you impacting? If you think of jurisdiction that way, that matters. And if you sit in Texas, but you're fundraising in Wyoming, Wyoming wants a piece of you because they want to know if you're actually raising money off their constituents. And Texas cares about you because you're sitting and you're incorporated in their state. They have other types of jurisdiction over you. So it's really important to do that. There are entire attorneys' practices around helping people and nonprofit organizations understand all of the state rules. It can be pricey. One of your first stops, if you don't have a lawyer in your organization, or you can't afford it, you're too small, or you're trying to figure it out and you want to ask questions, one first place to start is your CPA. Studies show, for better or worse, that nonprofits tend to rely on their CPAs, who are not lawyers, most of them, although some may be. But they do have a sense, if you get a lawyer who really does know 501c3 practice, they really do understand how this is supposed to fit together and can inform you when you need a lawyer. I exhort you not to find just any old CPA who will do your audit. They need to be a CPA that understands nonprofit practice. It's really imperative. And just having a lawyer on your board is not good enough. Two things. One, I started a nonprofit legal clinic, and the first thing I would tell the lawyers I was training is, you will be asked to be on 1,000 boards because you're a lawyer, and your malpractice will not cover any of it. Nor do lawyers find it easy to say they don't know something. So when somebody asks them, even though they work in securities and they sit on a board for the local theater company, when somebody asks them an employment law question, they feel like they are compelled to have to give you an answer, which may or may not at all be correct. So at some level, you have to cut bait and decide that you're going to go to a lawyer for certain issues. The sum of all of this is to say, there is an immense amount of knowledge out there about regulation. Your organization will, in fact, come up against regulation. It has to, if you have decided to get a tax break, or your organization and your donors are getting tax breaks. But once you've incorporated, once you also have tax exempt status from the feds, corporation, state level feds for tax exempt, once you know your filing requirements, and part of that is knowing where you do business, you're pretty good to go, I would say, with about 70% of what you're doing. But you have to check your state laws, because in some states, if you fundraise and you use external fundraisers, you have to submit certain contracts. Some states require a bond for certain things. The only way you'll know is to look it up. Now, I will also recommend to you the National Council of Nonprofits. They have a lot of help for organizations that are looking for state-specific help. Your attorney general's offices are extraordinarily helpful. They may have little or no charities bureau status, but they have somebody there, I promise you, that can help you or guide you to what you need to be doing. The help is out there, but you first have to know when to ask. And that's what I'm guessing that this course is about, is to help you know when to ask.
Yeah, very, very good advice. And in particular, the CPA, because we believe that the lawyer is going to fix everything. because the lawyer knows. But sometimes that is not true. Maybe having somebody who really knows about the tax exemption, the tax code, what you need to do to protect your organization at state and the federal level is what you need. And also all the requirements that you need to fulfill. That's very good and very, very informative and with practical advice to the students. The last questions is where are we going as a sector? So it's good to have this vision. So we have the for purpose, for profits. We have some changes, some hybridization of the sector, but maybe we are not making any progress in terms of changing the legislation in terms of the nonprofit sector, and also the changes that we need with all the things that are in motion. So how do you see the sector right now in the future? So
it's a great question. It's one I think a lot about. I've had a number of convenings around this with other experts as we are all thinking about this. So one thing is the situation with the IRS has gotten problematic over time in the sense that they've gotten a big infusion of money in this last cycle, but it's not clear how much of it is going to exempt organizations, if any. And it's problematic that it's become so lean at the IRS that for purposes of enforcement, most people in the sector, in any sector, would want the bad apples to be plucked out. It helps. I mean, our sector is based on trust. We call it a charitable trust for a reason. It is based on the notion that I'm going to give resources to a stranger who are going to then go use it for the stated purpose that they told me. That's a lot. And the more you attenuate by bringing in fundraisers who are other third parties, anytime you bring in another level of attenuation, you have just crossed your fingers even harder, right? That the resources are going to end up where they're supposed to. This is why, in theory, this is why we need enforcement in any sector, but in particular in ours, right? At least I would argue that. It's problematic. When we don't have enough resources, the audit levels are incredibly low for exempt organizations. It's kind of an afterthought. I do a lot of thinking about this. We're going to have another symposium through Urban Institute next year, kind of about the future of charities regulation overall. The states are far more active, but the states, I've worked with attorneys general a long time. I was a chief counsel in an office 25 years ago, and I can tell you they were the last bastion of really becoming more political. And at this point, it's seeped into that work as well. I don't mean it through their everyday work with their deputies who are all doing like yeoman's labor out there trying to do it right. The problem is the perception is that offices look and are perceived to be doing more political activity, even if they're not. And that comes into play, it has to come into play when you think about it, for nonprofits within a state, because when you have states that are banning certain things or saying that you can't engage in certain activities with state contracts, et cetera, that really impacts nonprofits. Nonprofits have a ton of state contracts in the services world, state and federal contracts. There are all sorts of nuances here that are behind the scenes, but then we also have some very major legislation that has come around that is changing. So the Bonta case is something you need to know about in this class. This was from, it's been now 2 years. Maybe I'm losing track of time, but in June, not last June, I think the June before, maybe last year, that because the case was argued so early. This was one of the only cases of late that has gone to the Supreme Court that directly came out of the charitable sector. And this is a case about donor disclosure that was based on the First Amendment. And as a result of the Supreme Court siding with the plaintiffs, which were very much a mix of strange bedfellows, it was both very conservative foundations and also the ACLU that went up against the state of California that was trying to get donor names as a matter of course for certain sliver of organizations that had certain revenues or certain donation patterns or whatever that were not to become public, but they'd had public data breaches before, and so it's problematic. This goes back to the First Amendment idea, right? We have a long-standing notion in this country that donating is also part of speech. And so if you are chilling speech through regulation that that would be problematic. And that is how the Supreme Court saw it. As a result of that case, in the last 18 months, we now have a wave of state level legislation that is protecting donor identity, that is protecting donor disclosure issues. And it's also saying states, you can't regulate in certain ways. This is pretty historic. This means that the states are now reaching into a certain type of regulation and literally saying, you can't do that. And that matters. So if we have less enforcement at the IRS level, because Congress has decided, to circle back to my early comments, Congress has decided not to fund certain types of activities at the IRS for the exempt organizations division. And then you also have at the state level certain things, whether you agree or not with the actual, whichever side people are on, the fact that there is this much activity, or that somebody is telling people, regulators, not to have activity, that in and of itself is an absolute value of activity that is going on here. There is churn happening right now, and it's not clear where it will wind up. I sometimes do a thought experiment. I'm thinking about this as a paper for next year with a symposium. What if we really let people have their way and just not have regulation in the sector in terms of statutes or anything like that? We just based it all on common law, right? What would that even look like? We have a lot of statutes in property law, but a lot of property law is still actually based on common law. I'm not saying I'm a fan. There are some people that would love this concept, but it is a thought experiment in the sense that what we have also, I should mention, a lot of what we have in certain aspects of exempt organization law at the federal level in particular, it's just obsolete. It doesn't look like the realities of what organizations do on the ground. Political activity is one of them. The C4 advocacy organizations, they're social welfare organizations, but this is the big hole through which many trucks are driven in order to get in certain types of activities that many people believe should be prohibited through the nonprofit arm of organizational form. And that's where Citizens United came in, was saying, we're going to allow certain things. We're going to allow it through speech. Those are very blurry lines right now. They've been blurry for a long time. And I often remind students that if you look at something in the law that's been problematic for people, but remains blurry, that means somebody likes it blurry. In fact, chances are, and in this case it's true, both sides of the political aisle are perfectly fine keeping those lines blurred, even though they may say they would like actually some clarity around it. But the reality is both sides are benefiting if it has stayed that blurry that long. And that is what we have right now with the C3, C4 split, as we call it. So I think that's a big one in question. The last two issues that I think people would need to look out for, that I have predicted for some time might change, and I'm not alone in that. Well, I may be alone on one of them because it's a bit blasphemous. In the law, the reason the Attorney General's office is actually really important for enforcement is that they stand in the shoes of the public. We have something in the law called legal standing, and it means you have to have a dog in the fight. More than just theoretically, you have to actually show that you will have harm in order to bring a lawsuit. Well, in the charities world and the nonprofit world, that's harder to show, right? Beneficiaries don't get to sue and say, hey, you raised that money for me and I haven't seen any of it. You can't sue for that. You don't have legal standing. Okay, what you didn't get, you weren't entitled to it in the first place, right? It's charities law, but it's not for the beneficiary on that front. Over time, I have predicted that we will see changes to legal standing. And in fact, we saw one just this year, a state that basically said, we're going to open up legal standing and allow other people to bring lawsuits on charities and nonprofit issues other than the Attorney General. We've had a few of those in the past. In certain circumstances, certain aspects others can bring, but it's basically been 99% of the time, it's the Attorney General office. Related to that is the last comment I'll make. I think the power of the donor has become the place to look for the largest change. It not only came from this Bonta case out of California. This predates that. all of you go to higher education institutions that have buildings and departments and endowed chairs named after people, right? Higher ed and medical institutions figured out a long time ago that they were going to do that. And the donors figured out a long time ago that they would have a contract in order to write that relationship up. It wasn't just going to be a donation, that there might be a contract involved. And that's always been, you know, it's a complicated and complex area to get into, but it was really the way that it first showed donors are not going to go quietly if you take their money and then don't do the thing they wanted with it, right? And so we've seen any number of lawsuits around that at this point. And I suspect that's going to grow. My most fervent desire is that someday our development teams will no longer put anyone's name on anything. Because at the end of the day, we've seen a lot of different names that need to come off buildings and come off endowed chairs because of ethical issues, because, you know, the whole tainted money thing. It's just complicated when you attach it to a human, since humans don't always do right. And then you have to figure out what next. But I think this notion around donors and their power and their ability to really make sure that donor intent is followed and how people look, which is a very strong concept in our space. I think eventually we will have more mechanisms for them to do their job. And at the rate we're going right now, we may have less mechanisms for the regulators to do their jobs. And that inverse is, to me, one of the most interesting things going on at this kind of historic juncture that we're having.
Yeah, no, a perfect self-regulation for the sector, but with some controls from the interested parties. So very good, Cindy. Thank you very much for your time, for all this knowledge and all your comments and all your recommendations. It has been an honor for me, and I'm sure that for all the students, they're gonna learn and they're gonna appreciate all your comments. Thank you very much for
hey, my pleasure. And really, it's an honor. And I, as an educator with my educator hat on, I'm thrilled that these programs exist in all sorts of schools. And you're very, very lucky, all of you, to have Dr. Ponce. So Carlos, thank you so much for asking me. And by all means, anybody that would like to get a hold of me or has questions for me, I'm happy to answer them. Okay.
Or want to move forward from the master to a doctorate, that's the place to go.
I was trying not to be a walking ad, but if you're interested in getting a professional doctorate, we now offer one at Indiana University, the only one in the world. And the next application cycle opens in July. So thanks for the opening. I wasn't even expecting it.
Oh, no, of course. Thank you very much.
All right. Thanks again. Good luck.